New Central now at this hour begins with updates on the End Bad Governance protesters facing treason charges. Youth Rights Campaign YRC has officially disassociated itself from the Russian flag displayed during the August 1 to 10 hashtag End Bad Governance protest in Nigeria. This follows the recent arrest of YRC National Coordinator Adarimoye Michael Lenin and Monsieur Sadiq by the Department of State Security and the National Intelligence Agency. At a Lagos press conference, YRC activists called for the immediate release of the detainees, emphasizing their lack of support for Russia and denying involvement with the Russian flag. National Secretary Francis Nwakpa urged the government to release Sadiq, who is reported to be in poor health and urgently needs medical attention. Meanwhile, a federal high court in Abuja has granted bail to the End Bad Governance protesters facing treason charges. The presiding judge, Justice Emeka Nwite, set bail at 10 million naira each, with a surety of the same amount. New Central's Joshua Imarayi has the details in this report.
The protesters were being charged with treason and being arraigned by the Nigerian police force on behalf of the federal government. The presiding judge, Justice Emeka Nwite of the Federal High Court in Abuja, following the hearing of bail application by the counsels of the defendant, granted bail to the 10 End Bad Governance protesters charged with treason to the tune of 10 million naira each. He says each defendant must provide a surety with the property in Abuja, depositing the property documents and swearing an affidavit of means. The counsels to the defendant, however, gave their position on the ruling.
Charges have been filed against 10 of the first set of 49 defendants. Another set of 79 defendants are languishing in prison custody as we speak, without trial, without arraignment in court. What now happens to the first sets of 49 defendants and the remainder 39 of the first sets that are still languishing in prison custody, whose only sin was their daring to challenge the states to end bad governance and make the country better?
I will not comment on the propriety or otherwise of what's already before the court. However, I enjoin the Nigerian government to get serious. Stop arresting labor leaders. Stop arresting protesters. Stop going after journalists. Focus on tackling insecurity in the country. Go and arrest Yabelu. Why are you scared of Yabelu?
The counsel to the Inspector General of Police, however, expressed different views.
So the issue of those defendants who have been separately remanded by the order of the court on a separate application, different from this one, can never be joined with this one. This ruling was based on the application that was moved in respect of this matter before the court. So the bail granted is only limited to this case and not to any other case.
Pursuant to the ruling of Honorable Justice Emeka Nwite, the court has scheduled a trial date for the matter on September the 27th, at which time the case will be heard. In Abuja for New Central, I am Joshua Imarayi.
Joining me to shed more light on this is legal practitioner and public affairs analyst Vincent Ottaokpukpu. Good morning, Vincent. You were in court yesterday. Can you tell us how the proceeding went?
Okay, thank you for having me, and thank you, our wonderful audience. I was in court yesterday, and the proceedings went beautifully fine. We were there as the head of monitoring team for the Nigerian Bar Association, because the Mazi Afamosigwe, president of Nigerian Bar Association, who was just sworn in, adopted an approach called the proactive bar and the responsive bar, part of which is what we have started. And there's a department called Pro Bono department in the National Secretariat to assist indigent Nigerians and who could not afford legal services. So we are there to monitor and will continue to monitor activities. The ruling, remember that these persons were arrested and arraigned on the 2nd of September this month on offenses bordering on treason, treasonable felony, and what have you. The court took oral application and adjourned 11th yesterday for ruling. The ruling was delivered and the fellows were granted bail, for which you have listed the terms and the conditions of bail, 10 million naira in lump sum for each of them. For surety, shall deposit the credentials and passport with the court. Surety shall have a landed property in Abuja. The defendant shall not participate in a public show or whatever, public rally and all those stuff, and or interview as the case may be. And that shall be detained pending when the perfection is done to their bail, the terms and the conditions of bail. So the court has the power to grant bail. Section 6, subsection 6A of the 1999 Constitution gives the court inherent power to grant bail as the case may be. Beyond this, the court predicated the action, the grant of bail, despite the fact that the offense for which they were charged bordered on capital offense, of which punishment is in most cases death by hanging on firing squad. Reference to section 161 of the Administration of Criminal Justice Act, which says, section 161 says, a person arrested, detained, and charged for offense punishable with death shall only be granted bail by a high court judge under a special circumstances. That is when the offense is committed and the punishment is death. Now, sub A says special circumstances means out of A health. B, sub 2 said certain circumstances can be described as 1 in the context of the section A health A, B when there's a delay by the prosecution. Then C, when in any other circumstances where the judge, any other fact, circumstances of fact which the court has considered to constitute exceptional circumstance, the court can grant bail in a capital offense. Then section 162 also was referenced by the court as part of the section upon which the grant of bail was predicated, that the court can grant bail to defendant charged with the offenses punishable with terms of imprisonment exceeding 3 years, as the case may be. Then section 163 also provided that the court, except in other grounds other than those listed by section 161 and 162 earlier mentioned, that the court can also grant bail under exceptional circumstances, which the court have exercised in this context. Now, we must know that the principles that regulate the grant of bail in our judicial, adversarial, judicial criminal system has to do with that the bail must be granted by the court judiciously and judicially for the interest of justice, taking into account the consideration some factors which the court, I believe, considered. One striking comment made by the judge yesterday in the grant of bail was that not minding the fact that the offense for which the defendant were charged borders on alleged capital offenses, the punishment borders on capital offenses, that the court is inclined to grant them bail for the interest and overall interest of justice. We say in law, pro bono publico, for the public interest.
All right.
And I want to tell you.
Yeah, sorry to butt in, but due to the interest of time, some argue that these bail conditions that you've also explained are too strict, making it unlikely for all the defendants to be able to secure bail. Can you tell us what's your view on that?
Yes. The Administration of Criminal Justice Act and the case laws litany and the copy of judgment already delivered by the Supreme Court, which borders on when the conditions of bail are stringent and harsh, and such that the defendant is not able to comply and perform or the condition for bail. There's a procedure provided under the law, which I believe that the lawyers in the matter should also adopt. By today, tomorrow, or next tomorrow, peradventure, they were not able to perform that. The law requires the counsel to apply to the same court for a variation. A court that have granted bail in a capital offense of this matter, alleged capital offense of this matter, can also vary the order by motion. Oh, my lord, the court has granted an order, certified copy of the order is hereby attached. The fellows have attempted to meet up with the terms and conditions of bail, but they have not been able to meet up X, Y, Z. The court for the interest of justice is hereby prayed to whittle down and vary the order so as to meet the interest of justice. I don't know. I don't believe that the court will say no, haven't granted bail. So bail in capital offenses are granted in exceptional circumstances. Supreme Court, in the case of Pius Oza and Ekwe versus COP, have also celebrated this kind of principle, which the judge followed, so it's known to law. In that case, Onitsha Main Market was caught ablaze in 1994. in an inferno, very serious one, that fellows were arrested, 9 of them. Also, Anekwe was charged before the Chief Magistrate Court on HR with 9 others for offense bordering on conspiracy and murder. Now, the magistrate, without jurisdiction, took their and detained them and in the prison custody. They applied to the High Court, and the lawyers applied to the High Court. They are entitled to bail under Section 241 of the Criminal Procedure Code. The judge took agreement of both parties and refused application because to him, it borders on capital offenses. On further appeal to the Court of Appeal said no, that the fellows are entitled to, that bail can be granted in a capital offense on the ground that when the judge, exceptional circumstances constitute that when the judge sees that there is no prima facie case or proof of evidence, the prima facie case attached before the court in support of the alleged crime, the court cannot just allow these people to languish in the detention. The court can grant them bail pending trial.
All right. Mr. Ottaokpukpu, let me come in quickly. Just one last question because we're out of time.
So that presumption of innocence,
I get your point.
Guarantees that the Constitution can make meaning in law. So the bail granted yesterday was a welcome development, and it speaks volume. The previous order made by the judge for detention within 60 days, which a lot of people have clamored, there's a pending application to set it aside, is of no moment and make no meaning again, because the judge has asked them to be detained for 60 days, have already now asked them to be released. So it's a welcome development and a good news for the defendant. It is also bad for those who have not been charged to court.
All right, I guess we'll come back. We'll talk about that one later on, those who haven't been charged, since our focus has been on those who have been charged. And yesterday we did get a statement, especially coming from the court. Thank you so much, Mr. Vincent Ottaokpukpu, for joining us here on News Now. Thank you.
Thank you for having me.
All right,
Thank
great. You.